In this case, Delhi High Court grants interim stay to Rotary's subsidiary on questioning the basis for further demands. Hence, activities connected to education cannot be treated as taxable business issued by suppliers which were duly reflected in Form GSTR 2A, not allow debit of an amount equivalent to such credit in electronic credit ledger. For discharge of any liability, the assessee was directed to pay 5 lakhs in cash as a precondition for unblocking the input tax credit. Under Section 107, which has the power to examine and reassess the evidence beyond the limitation period under Section 107, subsection 1, hence the High Court dismissed the writ petition. My dear friends, it's very important at this juncture to understand what is Section 161. GST Outlook for the week. GST Outlook number 1. My dear friends, GST Outlook number 1 relates to Delhi High Court. In the case of Rotary International South Asia Office versus Joint Commissioner CGST South Delhi and others, WPC 12539 of 2025. In this case, Delhi High Court grants interim stay to Rotary's subsidiary on taxability of club membership fees under RCM, that is reverse charge mechanism. The facts of the case is, the Delhi High Court stayed at show cause notice issued to Rotary International South Asia Office, subsidiary of Rotary International USA, demanding GST on club membership fees. My dear friends, in this case, the petitioner highlighted that 96 crores of GST on such fees had already been deposited and duly reflected in GSTR 3B returns, questioning the basis for further demands. It was argued that Rotary International USA does not receive payment from its Indian subsidiary, hence liability under reverse charge mechanism should not arise in the absence of any cross-border remittance. My dear friends, the bench specifically inquired about the justification for invoking RCM, that is reverse charge mechanism, when the entire GST liability on membership fees had already been discharged in India. Noting that the adjudicating authority is CGST, South Delhi, the court listed the case for further hearing on December 10, 2025, my dear friends. Keeping open the larger issue of GST treatment of membership fees and RCM applicability, this matter is a very, very important matter to be understood by all the GST practitioners and professionals. GST Outlook number 2 pertains to Supreme Court judgment, Joint Commission of Central Goods and Service Tax and others versus Goa University. Special leave petition civil diary number 43441 of 2025. My dear friends, in this case, it was held by the Bombay High Court. In this case, Bombay High Court quashed a GST demand of 4.83 crores on Goa University, holding that granting affiliation to colleges is not a commercial activity. My dear friends, the High Court gave a broad interpretation to education. In fact, what is education has been interpreted in this High Court judgment, wherein it concluded that the affiliation is an intrinsic part of the educational process and not a standalone business service, and commerciality cannot be attached. Accordingly, the High Court held that the university qualifies as an education institution since its dominant activity is imparting education. Hence, activities connected to education cannot be treated as taxable business. My dear friends, the revenue filed a special leave petition before the Supreme Court contesting the High Court's interpretation and quashing of the demand. Accordingly, the Supreme Court condoned the delay in filing, issued notice on the SLP, that is a special leave petition, and made it returnable in 4 weeks, leaving the issue open for further judicial consideration. GST Judicial Outlook number 3. My dear friends, it's a case relating to Madras High Court, Thiruvalar Guruammal Text versus Assistant Commissioner ST 2 WP MD number 21209 of 2025. My dear friends, High Court directs assessee to deposit 5 lakhs to unblock input tax credit. Department to pass order on show cause notice expeditiously. My dear friends, the facts of the case is, the department alleged that the assessee wrongly availed input tax credit on the basis of fake invoices and issued a notice in Form DRC-01. My dear friends, ITC was claimed on genuine invoices issued by suppliers which were duly reflected in Form GSTR-2A, making the credit legitimate. Pending adjudication, the assessee's electronic credit ledger was blocked under Rule 86A of the CGST rules. My dear friends, it's very important to understand Rule 86A of CGST rules. It is very important to understand about Rule 86A of CGST rules. It is provided conditions of use of amount available in electronic credit ledger, wherein under Rule 86A sub Rule 1, the commissioner or an officer authorized by him in this behalf, not below the rank of an assistant commissioner, having reason to believe that credit of input tax available in the electronic credit ledger has been fraudulently availed or ineligible as much as the credit of input tax has been availed on the strength of tax invoices or debit notes or any other document prescribed under Rule 36, issued by a registered person who has been found non-existent or not to be conducting any business from any place for which registration has been obtained, or without receipt of goods or services or both, or the credit of input tax has been availed on the strength of the tax invoices or debit notes or any other document prescribed under Rule 36 in respect of any supply, the tax charged in respect of which has not been paid to the government, or C, the registered person availing the credit of input tax has been found non-existent or to be conducting any business from any place for which registration has been obtained, or the registered person availing any credit of input tax is not in possession of a tax invoice or debit note or any other document prescribed under Rule 36, may, for reasons to be recorded in writing, not allow debit of an amount equivalent to such credit in electronic credit ledger for discharge of any liability under Section 49 or for claim of any refund of any unutilized amount. My dear friends, to balance interest, the assessee was directed to pay 5 lakhs in cash as a precondition for unblocking the input tax credit. Upon such deposit, the blocked credit in the electronic credit ledger was to be unblocked and the authority was directed to pass a final order on merits expeditiously. It was held in Madras High Court, Thiruvalar Guruammal, Text versus Assistant Commissioner ST, WP number MD number 21209 of 2025. GST Judicial Outlook number 4. It is a case of Orissa High Court, Savitri Industries versus Chief Commissioner of Commercial Tax and GST, Cuttack, WP number 17292 of 2025. It was held in the High Court. The High Court dismissed writ petition as assessee failed to approach it within time limit specified under GST Act. My dear friends, the facts of the case is the assessing authority raised a demand under Section 74. We all know about Section 74, how it's been used by the department, by disallowing input tax credit, citing that the supplier failed to discharge its GST liability by not filing returns for transactions with the assessee. My dear friends, the issue involved factual disputes, whether ITC could be denied solely due to the supplier's default, which required detailed appreciation, reappreciation of evidence. Such factual determination fall within the jurisdiction of the appellate authority under Section 107, which has the power to examine and reassess the evidence. If you see Section 107, Section 107 provides for appeals to appellate authority under Chapter 18, Appeals and Revision. Under this, it is clearly provided any person aggrieved by the decision or order passed under this Act or State Goods and Service Tax Act or Union Territory Goods and Services Tax Act by an adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which the said decision or order is communicated to such person. My dear friends, accordingly, such factual determination fall within the jurisdiction of the appellate authority under Section 107, which has the power to examine and reassess the evidence. Since the dispute was fact intensive, the writ jurisdiction of the High Court was not considered the proper remedy. The assessee should have pursued the statutory appellate route, subject to pre-deposit under section 107 subsection 6. The impugned order was passed on 25/2/2025, but the writ was filed only on 13/6/2025 beyond the limitation period under section 107 subsection 1. Hence, the High Court dismissed the writ petition, reiterating that appeal was the appropriate course. It was held in Orissa High Court, Savitri Industries versus Chief Commissioner of Commercial Tax, GST Cuttack, WPC number 17292 of 2025. GST Judicial Outlook number 6. My dear friends, is a case relating to Delhi High Court, Mark Agency versus Department of Trade and Taxes, WPC number 9700 of 2025. It was held in this case, rectification application to be decided after hearing party if decision is to go against said party. My dear friends, the facts of the case is, the assessee received a show cause notice raising a demand under various heads, filed a reply, but the authority confirmed the demand without favoring the assessee. The assessee moved an application under section 161 of the GST Act seeking rectification of the impugned order. My dear friends, it's very important at this juncture to understand what is section 161. My dear friends, section 161 provides for rectification of errors apparent on the face of record. Accordingly, I quote the exact words of the Bar Act. Without prejudice to the provisions of section 160 and notwithstanding anything contained in any other provisions of this Act, any authority who has passed or issued any decision or order or notice or certificate or any other document may rectify any error which is apparent on the face of record in such decision or order or notice or certificate or any other document, either on its own motion or where such error is brought to its notice by any officer appointed under this Act, or an officer appointed under the State Goods and Service Tax Act, or an officer appointed under the Union Territory Goods and Service Tax Act, or by the affected person within a period of 3 months from the date of issue of such decision or order or notice or certificate or any other document, as the case may be. In these cases, rectification may be taken up. Accordingly, my dear friends, as per the third proviso to section 161, here very important to understand the third proviso to section 161, wherein provided also that where such rectification adversely affects any person, the principles of natural justice shall be followed by the authority carrying out such rectification. Accordingly, assessee moved an application under section 161 of the GST Act seeking rectification of the impugned order. The rectification application was rejected outright without affording the assessee any opportunity of being heard. As per the third proviso to section 161, principles of natural justice must be followed, particularly when an adverse decision is contemplated. My dear friends, the rejection order was set aside and the matter remanded back to the adjudicating authority to redecide the rectification application after giving proper hearing to the assessee. It was held in Delhi High Court, Mark Agencies versus Department of Trade and Taxes, WPC number 9700 of 2025. That's all about GST Outlook for the week. Signing off, Advocate Dr. M. Satyakumar. Thank you so much.